Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I am your host while we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us, actually, we are not live this afternoon. We were supposed to be live, but we are pre-recording just a few hours earlier because our guest today, Matthew Fogelman, who is with us out of Massachusetts, has to be in court this afternoon. So we all know how that goes. Sometimes we expect things to be at a certain time, and we're just kind of like, oh my gosh, well, guess who takes precedent over the podcast? Mr. or Miss Judge. So we are pre-recording this. If you have questions, we'll certainly put Matt's contact information in the description below so you can reach out to him for more information after this podcast. But despite that, please hit the subscribe button, click that alerts icon so you don't miss an episode, whether it's live or pre-recorded or a replay or all the various ways you get little nuggets from us here on the Keenan's Cutting Edge podcast. As usual, we have a wonderful guest today, Matthew Fogelman. And I mentioned he's from Massachusetts, right? We have had Massachusetts guests before. I love having people from different parts of the country on the podcast. A lot of times we're focused in the Southeast, which is fantastic because we have a lot of Southeast practitioners, but it's fun to have folks from different parts of the country. Matt practices personal injury and employment law. So we're here to talk about an employment verdict today. Really special to have an employment lawyer on, as we have fewer of them in KTI than personal injury. And I know we're always hungry to hear about those employment verdicts. So Matt, I'm going to turn it over to you. Please share with us about your exciting verdict, your exciting practice, and how you utilize some edge techniques in your employment practice.
Yeah, thank you so much, Jenna. It's great to be here with you. I appreciate it. So I practice personal injury and employment law in Newton, Mass, a big city outside of the city, Boston, close to downtown. And we've got 4 full-time lawyers here, and we've got a good little small operation going. And I love what I do. I find it's interesting with both PI and employment. You have people that are in a bad spot, right? Mm-hmm. They've been injured physically, emotionally, financially, maybe all three. And they need help. So I actually find a lot of overlap between those two areas. And I enjoy the mix of the two. I think they work well in tandem. Mm-hmm. The particular case I had a trial a few weeks ago was a $2.46 million verdict against Brandeis University, which is here in Waltham, Massachusetts, and a couple of individual defendants as well. And in a nutshell, the case was my client was a Black female who was, at the time, this is 2017, 2018, she was the head of human resources. There was a men's basketball coach at the university who had made some racist comments to some Black student athletes over a course of a couple of years. The coach was white. And for various reasons, and you can tell me how specifics you want me to get on kind of the background, he was allowed to stay at the university. In my opinion, he should have been terminated earlier in time, but he was protected, and his supervisors were friends with him. And the program was a successful program, Division III, but nonetheless
hard to beat those sports guys, man. I mean, they bring in a lot of money to the schools. So
even Division III athletics can be very, very important to at least a certain group of people.
Definitely.
And so he was allowed to get away with some pretty bad stuff for a number of years. In 2017, 6 students came forward to file a formal complaint about the coach. 5 of the students were Black and 1 was white. Mm-hmm. And per the university's policy, and he had made some more discriminatory comments. What happened was that it wound up in human resources lap for them to do an internal investigation. Mm-hmm. And my client was the head of HR. She used one of her right-hand people to do the investigation. The investigation lasted a few months. And at the end of the investigation, that also took place over the summer in 2017, And college campuses tend to empty out over the summer, so it's harder to reach people. As the new semester started, the investigation was wrapping up. And what the investigation found was that the coach had violated the school's non-discrimination policy, and that he had violated the conduct policy, which really involved a lot of profanity and saying some not very nice things to these kids. Very importantly, human resources was not the decision maker. In other words, they made findings of fact, as I just explained to you, and then the decision went up to his superiors. Well, his superiors were friends with him. And again, I don't know how much detail we want on this piece, but they, in the decision makers, did not adopt the HR finding that the coach violated the discrimination policy. They found that to be unsubstantiated. And as a result, the coach got a slap on the wrist, but was not dealt with that harshly, was allowed to stay in his position, return to coaching. And then everyone kind of went back to what they were doing, right? Coach went back to coaching, HR went back to HRing, and so forth. A couple of months later, a seventh student came forward with additional allegations of discrimination that were even worse than the other ones, but the other ones were not great by any means. And, we argue that, the coach was emboldened by the failure to kind of crack down on his conduct in the first place, and went on to make these other really incendiary remarks to this one student, including that he was going to ship him back to Africa. So this now became a big deal, right?
That's shocking.
Not good. Now it's becoming public because students are now really upset. The media started to call, and as happens in these situations, the school now they have to take action, right? Because things are kind of blowing up in their face. And obviously everyone's always concerned about reputation and brand. And so they go into action, they go into spin control and PR mode. They wind up hiring an outside law firm to do an investigation of the investigation, right? Essentially, like, what happened in the earlier investigation, who found what and who overruled what, and why did the coach stay? So they bring in this outside law firm and they perform a months-long investigation. Now, I could tell you what went wrong. What went wrong is that the school kept the coach for too long, and they should have gotten rid of him when they had the opportunity. And then none of the rest of this would have happened, right? There wouldn't have been a seventh student. There wouldn't have been the need to hire an outside law firm because you would have dealt with it, taken care of it. But they didn't do that. The outside law firm made some recommendations for discipline to the school. And they recommended discipline for a few different departments and a few different people. They also identified other people that could be potential candidates for discipline, but they really left it up to the school. In other words, the outside law firm did not say, they didn't specify the form of discipline or the type. They didn't say that all the discipline should be the same. And as I talked about in the case, discipline can mean a lot of things, right? Discipline can mean firing, suspension, demotion, pay cut, training, warning, written warning, verbal warning. And those are all considered discipline, right? So that was really up to the school's discretion. And what the school did was they wound up disciplining 3 people for everything that had happened, allowing the coach to stay, overruling the HR findings, and actually finding that HR made some mistakes as well. And that was my client. And they wound up disciplining 3 people for this. Now, all 3 people that were disciplined were women. There were men that were possible candidates for discipline. None of them were disciplined. 2 of the women that were disciplined were white, and 1 was black, and that's my client. And we argued at trial successfully that there were numerous instances of discrimination and retaliation in this case. I'll get to the retaliation part in a second. I'll be done with my summary. But one of the problematic things was that, first of all, that the only people that were disciplined were women. That was problematic. And
the other two have legal counsel? Were they involved in the case at all? Or did they have cases? Or is it just your client?
they did not have cases. They were witnesses at the trial.
Okay.
One of the women, so all three were demoted and all three got pay cuts. One of the white women decided she didn't want to take her demotion. She wound up leaving the university and getting a severance package. Mm. That left two, the other white woman and Robin. Mm-hmm. Now, Robin, whatever infractions they say that she committed, paled in comparison to what the two white women did. Mm. Because the two white women are the people that had oversaw the coach for many years. And so they enabled and stood by, his conduct. Mm-hmm. Not that they engaged in the conduct, but they were in charge of someone who was doing bad things. Mm-hmm. Whereas HR, there was some indication that maybe the investigation had taken too long, that there were some redactions in the report that were maybe too heavily redacted, and that they, when they were meeting with the students afterwards, they should have reminded them of a couple of things that they didn't tell them. So technical infractions, but not a big deal in comparison to what the other people had done. Mm-hmm. And we argued that the discipline that was given out was not commensurate with the gravity of the alleged wrongdoing. And that was against my client, who was Black, who sort of got lumped in with these other people, even though what she did paled in comparison to what the other people did. And also the men who were not disciplined at all. Mm-hmm. And then after the demotion, the school treated my client much worse than they treated the white woman who got demoted. Robin had to jump through a lot of hoops to kind of prove herself after she was demoted. She reported to a new supervisor who was very terrible to her. And we can get more into that, today. Mm-hmm. But so that played into our claim as well, that the way that these two people were treated post demotion was very, very different from each other. Mm-hmm. And then finally, my client filed a charge at the state discrimination commission, and then ultimately in court while she was still there, and she wound up getting fired. And so that played into the retaliation claim as well, that she engaged in protected activity and then was terminated. They argued that, of course, that's not why they terminated her. They argued that they terminated her because of performance, and that she, after she was demoted, she was so upset that she didn't really want to engage, and she checked out. Mm-hmm. That was their defense.
Interesting. They always come up with something after the fact, don't they? They always come up with something. All right.
Yeah. So it was a 7-day trial, full days in Massachusetts, which is about 6 hours a day. Okay.
And so employment law, for those of us who practice it, is very fact oriented. It's very fact based. I mean, there's always like all these stories, all these things that happened and everything. How did you manage to distill that down into 7 days of testimony, and who did you bring to trial to talk about it? What witnesses?
Sure. So we tried to be very efficient. I tried the case with my partner, Jeff Simons, and we knew that we needed to be efficient. We wanted to get the case in. I think having the jury there for fewer days rather than more days is usually good for plaintiffs. And we were very organized, and I think we're very efficient. We called a few of the individual defendants from the school. We called in our case. Mm-hmm. And then we called Robin, of course, several damages witnesses, her sister, her daughter, and a good friend of hers. And then we also called a few of the other people that were involved. So like these two other white women that I mentioned to you, the investigator that worked with Robin on the HR report. I think that was it from our, we had an expert as well. We had an expert. Yeah, that was
What expert did
interesting.
you have? Yeah, because we have one in one of ours, and I'm curious how you used them.
Yeah, Peter Glick, he's out of Wisconsin. The main thrust of his testimony was to explain to the jury how implicit bias works, and that everyone has certain implicit biases, but how that shows up in the workplace. And he had some good statistics about women in leadership roles and non-white people in leadership roles, and also really interestingly, certain group stereotypes that are associated with different groups, and how the adoption of those stereotypes can kind of manifest itself. He did not say that the college discriminated against her because of XYZ. It wasn't that type of expert. It was just to explain to the jury, the science really of bias. What is it? How does it operate in society? And what are some things that we see in terms of human behavior where those biases and those stereotypes manifest?
Okay. What kind of jurors were you looking for on this case? And did you get that? Well, it sounds like you got them, but what kind of people were you looking for, and how did you go about choosing them from the veneer?
Yeah. I think probably consistent with a lot of our colleagues. I was looking for people who, first of all, agreed and understood that racism and sexism are real things, right? And I think most people believe that, but not everyone. I'm sure we've all met people who don't believe that, or they believe that people are too woke, and racism and sexism have gone too far. You know what I mean? Like I don't know exactly what those people think. I don't think that, of course, but I wanted people who would understand and would be open to the concept that a Black woman was not treated equally to white people. And it was interesting because she's both Black and a woman, right? So it's just an interesting twist to a case. And maybe you sometimes you might have a white woman who's claiming gender discrimination, or you might have a Black man claiming race discrimination. But here there were both elements. And so I was looking for people that would just be open to that. I was also looking for people that, and again, this is going to be true for most of our cases, but I talked about it in jury selection, that believed that emotional distress was real, right? And you're going to have, and we had one possible member actually on the panel, and she was struck for cause, but she said, maybe everyone goes through something, but I don't think you get money for that. And she committed to the fact that you just don't get money for emotional or mental suffering. Mm-hmm. So I obviously wanted to make sure that there were people that did not feel that way. I also talked in jury selection about reputation. We had a good discussion about what does it mean to have a reputation, your good name, right? Because there was an element to this case I didn't mention, but when they disciplined the three women, they sent out an email to the entire community informing them of the discipline. Also posted it on their website. And that was contrary to normal procedure, where personal matters are supposed to be kind of kept confidential. Their argument for that
PR thing, kind of like, look what we did, we took action, look at us.
Correct. And they claimed that it was for transparency. But the result of that was harm to the three women, right?
Sure.
And so, and part of Robin's motivation in bringing this case was to help clear her name. I mean, of course, compensation is always going to be a part of the case, but it really was not her driving factor. She really was desiring to clear her name. And the way to do that was through a trial. And so I did talk about reputation in voir dire because I wanted to have the conversation and I wanted to see what people thought about the importance of one's name. So those were the major topics in voir dire that I talked about. It wasn't necessarily looking for a type of person, if you will. When you ask the question, I mean, it wasn't like I didn't say, oh, I need older people or I need younger people, you know. I definitely wanted to have some women on the jury because my client's a woman. And I don't think it's a stretch to say that women are going to have a better understanding of what it's like to be a woman in the workplace than a man will.
Were you worried that it might be kind of a negative attribution? Like, well, I wouldn't sue if that happened to me, or I wouldn't, you know, feel like that's a big deal, or, you know, did you worry about any of that? From the women, sorry. That's
yeah, no. It's a great question. And I mean, we always have to think about that, right? In any case. And so, yes, I did think about that. But I tried not to overthink that point, you know, because I felt good about our case. I felt confident. I felt like we had the better case. And I felt like I was on the right side. And my client was really good, you know? And so I tried to have the philosophy in jury selection of finding the people that would be on my team. And in so doing, find the people that were going to be bad, right? The lady who said, you don't get money for pain, for mental suffering. Mm-hmm. But, and, you know, I'm happy to, I know sometimes in KTI, we're looking for the bad jurors, right? We're looking for the people, we're trying to eliminate the people that are going to be bad for us. I actually tried to come at it from a slightly different angle. I tried to come at it to let me find the people that are going to be good for me. And in so doing, I'm going to find the people that I think are going to be bad for me. But I came at it with a slightly different mindset, I would say. And that works for me. I don't know, you know, everyone's different, but it worked for me because I feel like I came at it not from a place of fear of who here is going to kill my case, you know? I wanted to come at it from more of a positive place almost, you know, like this is our case. This is a good case. I believe, folks, this is what I was thinking, right? When you hear the case, you're going to agree with me that it's a good case. You're going to agree with me that I'm on the right side. You don't know it yet, but you're gonna get there. And so I was trying to just find those people that I felt would get it. You know, does that make sense?
Absolutely. Yep. Absolutely. That makes sense. And I'm always curious. I love asking about the jury selection questions because I don't know that I have the best radar when it comes to who's going to be good on my team and who's not. And so I love hearing, you know, just the little indicators, the little thing. I mean, I've had guests on who said, you want to choose people who are positive, who are kind of smiley, whose body language is open, you know, things like that. And that's stuff that Papa Don talks about too. And, you know, in Edge, we always talk about voir dire being the team building, right? That's the purpose, is building that team, getting people together, getting the crosstalk going, getting everybody to kind of like start enjoying being in each other's presence. And then when you see that person singled out, who's like the rat, that's what we call him in engineering, rat, that's the person you target to try to get off the team. And you know what, if they're on your team, hopefully they don't poison the water too badly.
100%. So I agree with everything you just said. And that is entirely consistent with how I approached it.
Okay.
Entirely consistent with how I approached it. And, you know, asking questions, I was also trying not to make a statement and then say, who agrees with that?
Yeah.
I wanted to sort of have them tell me what they thought, you know, so you can tee up the questions in a way that hopefully they're going to tell you, like with the reputation thing. I wanted them to tell me reputation is important. All you have is your good name, right? I think it's so much more powerful if the jurors, the panel is telling you that, rather than you saying, now reputation is a really important thing, isn't it? Who agrees with that?
Mm-hmm.
You're ultimately getting the same words are being put into the air, but I'd rather hear it from them.
Mm-hmm. How did you frame your question about, or start the discussion on reputation?
I think I said something like, one of the issues that you're going to hear in this case is that someone's reputation was damaged. And I would just like to know from folks, what do people think about reputations? What does it mean to have a reputation? And thankfully someone's hand went up. Reputation is really important. Oh, tell me more, sir. What do you mean by that? Right. Well, all we have is our name at the end of the day. And if somebody sullies that, and then you get a discussion going. And does it matter whether if it's at work? Is that different than if someone posts something on Facebook? Well, does that have as much impact? Is it if it's at work, is that more or more important or less important? Right. Just wanting to get that discussion going. And to your point, right, then hopefully the rat identifies that themselves, right? Or maybe you can tell through body language, or someone who maybe they just don't, if they don't want to be there, I don't want them to be there.
Absolutely.
So you're looking for that as well, right? But I guess in the reputation, I don't think there was anyone who said, "Oh, I don't think that's very important." Nobody really said that, So, it was, I really enjoyed the process. The judge, we did some sidebar, and then we also did some panel. So it was kind of a mix.
Okay. But yeah, tell me a little bit about what it looks like for you in jury selection, because those of us all over the country have all kinds of different ways. So you're able to question them some individually? And
yeah, so the judge posed a lot of questions to the entire veneer. The statutory questions, but then some additional questions as well, because this case dealt with some discrimination. That's a heavy topic, right? It's a heavy, sort of sensitive, button pushing topic. And so because there were a lot of questions that were posed to the veneer, a lot of hands went up for different questions. And so what the judge did was call each person up to sidebar. We had a short discussion at sidebar about what they had raised their hand to. The judge asked a question. She allowed a little bit of attorney questioning at sidebar, not really a lot though, but we still got the opportunity to meet them, right? And look in the eye, and that's important. And then from there, she either struck them, because they said something that was in favor of one side or the other, or they had a vacation or something. And if not, then they went into the box.
Okay.
And then there wound up being 20 people in the box. And then each side got about 25, 30 minutes with the 20 people in the box. And then we used our peremptories from there.
Okay.
Leaving us with 8.
Oh, okay. Okay. All right.
Massachusetts used to do juries of 12. With COVID, we went to juries of 6. That has stuck around. And so it was 6 with 2 alternates, therefore 8. But in the end, all 8 wound up deliberating.
Oh, okay. So they all did. Okay. So then do you have to have a unanimous verdict, or are you 6 out of 8, or how does that?
7 out of 8.
7 out of 8. Okay.
Right. So in Massachusetts, it's 5/6.
Okay.
So 8, which is 83.3%, right? So if you have 6, it's 5 out of 6. If you have 8, it's got to be 7 out of 8, because 6 out of 8 is 75%, which is less than 83%.
Okay.
So if you had 10, you'd need 9 out of 10, because 8 out of 10 is less than 83%. But if you had 12, you'd need 10 out of 12. So it's it's just a numbers game of how many you have, but it's not unanimous. Okay. So with a jury of 8 or with 6, you can have one person who's not on board.
Okay. And how was the decision made to include the alternates in the deliberations?
So the judge was encouraging counsel to do that. And both counsel had to agree to that.
Okay.
But I think we did. I think we agreed. I mean, I think, everyone had been sitting there for 7 days.
I know, I always feel so bad for the alternates.
Right. Yeah, you kind of feel bad for them, right? I mean, I guess there's some strategy involved. But the thing is, the way they do it here is that you actually don't know who the alternates would be. Mm-hmm. So if you had 8 and a lawyer said, I only want 6 deliberating, mm-hmm. they would basically pick out of a hat which 2 people would not be deliberating. Mm-hmm. And I mean, that's a risk, right? What if you think that a couple people are really with you and they now they're not, because they're not part of the 6. And I think defense counsel felt the same way, right? I mean, mm-hmm. if it's same risk, right? If they felt that some people were with them, they wouldn't want to lose them. So,
right. Oh, I see. Okay.
Right. I mean, it kind of cuts both ways fairly. They were out for 11 hours, which is a pretty long time.
Yeah. Did you think during that time, did you feel confident? Were you worried? Did the time at all play into it? Because sometimes if they come back quick, you're like, oh God, it's a defense verdict. Or if they take a long time, you're like, yes, keep thinking.
I think the traditional thinking is if they come back too quick, that's probably not good for plaintiffs. Mm-hmm. I think you're right. The longer they're out, I mean, they got to be talking about something in there, right?
Yeah. Yep.
The reason that we felt pretty good was we actually got a couple of jury questions. Okay, and they were pretty positive.
Okay.
They were pretty positive. One other really interesting thing I can mention about the trial, and I don't know other states, is that the judge allowed the jurors to ask questions after each witness was done testifying.
Oh, yeah. Actually, that was my next question for you, because in Washington, we have that, and I love it. It's very insightful.
It's so insightful. The lawyers have to agree to that as well.
Mm-hmm. Okay.
So it cannot be forced upon the lawyer. Mm-hmm. But again, I think both sides usually can benefit from it, right? Mm-hmm. I mean, whether it's good, bad, or indifferent, isn't it helpful to know what these people are thinking?
Yep, definitely.
So I was a little bit apprehensive about it at first, to be honest, maybe because of a control concern, like I want to control what evidence is going in. Mm-hmm. But sometimes you have to relinquish that, and we relinquish that when we give them the case for deliberation, right? And so I found it helpful and very insightful, and then you're able to even try to take some of what you're hearing, and there weren't a ton of questions, but there were a few, and then you can take some of that and you can build it into your case going forward.
Yep. Yeah. I mean, actually, along those lines, did you do any focus groups beforehand? Because that kind of is a way also to kind of find out what regular people are thinking about the case and folding it in.
We did indeed. We did three, okay. Which for me was a lot. In the past, I've maybe done 1 or 2. Mm-hmm. But we knew this case was going to trial. And so, yeah, we did 3. Okay. And they were extremely helpful. Mm-hmm. Extremely helpful. And we sort of did different types of focus groups as well. I think the first one we did, we just sort of gave the fact pattern and just wanted feedback. Like, what do you guys think about this? And it was very open. And then another one we did a plaintiff's opening and a defense opening.
Okay.
And then the last one we did, I just did a plaintiff's opening and basically said, make this better. How do I make this better?
Okay.
Like, what worked for you? What didn't you understand? What would you emphasize more? So they were different in the way that we did them and what we were looking for. And we got what we're looking for. The other, I want to go back to one other thing you asked me before when you were talking about the types of jurors, and I mentioned, wanting some women, of course. We wound up having four men and 4 women. But the jury was all white, which was interesting because my client is Black. Mm-hmm. And if you asked me if I wanted some non-whites on the jury beforehand, I would have said yes. I would have said yes for the same reason that we talked about, on the gender side, right? I mean, you're going to have a little bit more of an understanding of what it's like if you walk in the same shoes. Negative attribution aside.
Mm-hmm, mm-hmm, absolutely.
but you get who comes into the courtroom that day, right? And there were some non-white jurors in what came up the sidebar and said, I've got a medical appointment, I've got, whatever. So that's who we wound up with. But, as I said before, they got it.
Mm-hmm.
They got it.
Yeah, they definitely got it.
Yeah.
So how did you come up with the number you're going to ask for? What did you ask for? And is that what they gave you?
It is not what they gave me. Okay. I'm happy to tell you what I asked for. So I asked for $310 in wages, because that was what the lost wages were. Basically, I don't have to get into the whole I asked for $310 for wages because that's what the wages were.
Okay.
I asked for $1.7 million in emotional distress damages, and I asked for $13 million in punitive damages.
You have punies up there. Okay, I always forget to ask that because we don't have them in Washington. So
we do. Oh, you don't have them in employment cases?
No. There's a kind of a caveat. If you're in federal court, you sort of can kind of weasel it in under some circumstances, but yeah, state court never.
Okay, got it. So in Massachusetts, it's statutory. So you don't, in personal injury cases, you don't have them.
Mm-hmm. Yeah, no personal injury or employment or nothing. Med-mal, nothing.
Got it. So under our state law, chapter 151B, that's our discrimination law,
mm-hmm.
You can get punitives. Now, obviously, not every case is a punitive case, of course, right?
Mm-hmm.
But most judges here will at least send the question to the jury.
Okay.
Because I think, if they don't allow the jury to opine on punitives and then you get a verdict, then now the plaintiff has an appellate issue.
Mm-hmm.
The judge did not even allow the jury to weigh in on punitive. So I think it's probably the safer course for judges to allow the jury
mm-hmm.
to weigh in on punitives. And obviously the judge has discretion to modify that if they want to.
Mm-hmm. Mm-hmm.
So that's what I asked for. So if you total up my ask, it was 15 million. Pretty aggressive ask.
Mm-hmm.
I felt that it was warranted. I felt that it was warranted under the circumstances.
Oh yeah, certainly. Did you feel like when you asked that number, was there a response from the jury? Were they shocked at all, or were they just kind of like, all right, that's your ask, or anything?
I did not feel shock. I did not see anyone recoil.
Mm-hmm.
And some people that were watching the closing, I asked them that as well, and they did not sense that either.
Good.
I felt good about it. I felt good about the number, and I feel like I think I stood in my power, and I think I did it confidently, and I truly believed in it. And I think that comes across.
Mm-hmm.
They did not give me that.
Mm-hmm.
They gave us the $310 in wages, $650 for emotional distress, and $1.5 in punitives, for a total of $2.46. And I will say, that's a really, really good number.
It's fantastic.
Some people said, well, are you disappointed because you asked for so much more? The answer is no.
Mm-hmm.
I'm not upset that I asked for that. I think that was the right ask, and it felt like the right ask. But wow, we were so pleased, we got every category we asked for, right? We got wages, we got emotional, mm-hmm. we got punitives. And there's cases where you don't get any emotional or you don't get any punitives.
Mm-hmm.
And that's happened to me before, so to get all three is wonderful. And the client was so gratified because, and I don't mean to sound hokey here, but she really did want and need the jury to understand what she went through, to understand that she had been wronged, and to help to right this wrong, and help clear her name, as I said before. And she was crying when they started delivering the verdict, because question 1, yes, question 2, yes, that type of thing.
Oh my God, I'm getting goosebumps right now.
Yeah,
I can only, that's such a great feeling. Congratulations. That's awesome.
Yeah. Oh, thank you. Yeah. It's pretty special. It's
a lot of weight. That's a lot of weight on your shoulders, right? And it is, we all carry that for our clients, but in particular in a case like that, where she really needed that validation from the jury, and you're like, whew, man, if I don't deliver, how did you manage that?
Yeah. So from the first day she walked into my office, she told me that she did not want to settle the case.
Mm-hmm.
And she was never wavered from that. Never wavered from that.
So you knew you were going to be trying the case.
I knew. And there are people that say that, but most people at the end of the day would rather resolve a case than take the risk.
Definitely.
Not everyone, but most plaintiffs, right? And there's reasons for that, right? Because there is risk. Of course there is.
They're tired of however many years you've been going through all this, and they're like, oh my gosh, another 3 months. I don't know if I can take it,
Yeah. And it's stressful to prep and to sit there in court every day. I mean, that is not for everyone, but I knew that that's what she required. And I would say it's the rare plaintiff, not totally unheard of, but rare, that really says from day one, I'm taking this all the way. Are you with me? And I was, I always liked her so much, and I always thought it was a really good case. And yeah, we hopped on that bus together, and almost 5 years later.
Wow. It is so amazing to think about when, I don't know, at least in Washington, our litigation part is fairly short. It's usually about a year and a half. We get a date and it goes. But we tend to have the clients for a lot longer as they're working through things, as they're working, personal injury, of course, as they're working through injuries, employment, as they're working through kind of getting out of their situation. And so you just have such long relationships with these folks.
Yeah, I mean, it's a great thing about representing real people, and it's one of the really nice things about doing plaintiff's work, right? Is that you can form these relationships, especially with a client that you really, really like, and that you really connect with, and yeah, to be able to develop that relationship, and one where we could push back on each other on certain things, right? I mean, she was involved with trial strategy and witnesses and documents, and it's a cool collaboration, when it works, right? When it works well, when the stars align in the right way, with a client or with a case, that's pretty special. And as we all know, they don't always align. In fact, a lot of times they don't align in the right way.
Absolutely.
But sometimes they do. And it's a beautiful thing.
Yeah, that's it. And then are you able to say anything about pretrial offers? Was there ever one that I know she was committed to trial, but was there ever one that was reasonable to the point where you were like, maybe we consider this? Or were they all low balls?
I probably should not get into that too much.
Okay.
I will say, I think what I can say is that there were some discussions, but she was not interested. She really was not interested.
Can you say if you beat the offers that were on the table with your verdict?
We did.
Okay. That is always a real good feeling. That's such good justification, at the end of the day. Number one, you won. Number two, you got the validation of the jury saying, yes, we are with you. And number three, we got more than what was on the table. Whether it's $1 or who knows how much. Well, all that matters. So awesome.
Right.
Well,
right. And then in Massachusetts, we also, under the employment, I think you guys have the same thing, but we can put in a fee petition.
Yeah.
For attorney's fees. And so, on top of the verdict, so we also get prejudgment interest.
Oh, okay. Yep. Yeah, I think we do have that. Yeah.
Yeah. Well, I think
it seems to be so small. But...
Yeah. So on top of the verdict, you get some interest and then attorney's fees.
Okay.
Yeah. Fantastic. And well, yeah, I guess that's.
Well, I mean, of course, we know, as everybody knows, there's always motions flying after the fact. And so we'll, see how things turn out. But congratulations. I mean, we're just so proud of you to have you in the KTI family, another feather in our cap. It's such a wonderful verdict for a deserving client. Any last thoughts that you want to share with us this afternoon?
Yeah. Thank you. Thank you so much for everything. I guess a couple of just last thoughts is, don't come from a place of fear. You know, if you can come, again, it sounds a little hokey, but coming from a positive place and just being confident, not being too cocky, but just being confident. I feel like the jury just picks up on that, you know, whether it's even nonverbal things that one might do, the way that you stand, the way that you hold yourself, the way that you move about the courtroom, you know, modulating your voice. I feel like we projected that from the very moment I stood up and introduced myself to the very end of closing. You know, the way that you talk to the judge, just show up, right? Like show up in a big way. And again, it doesn't mean cocky, and it doesn't mean arrogant, and it doesn't mean being a jerk in any way, shape, or form, right? We're polite, respectful, but you gotta swing. Right? Sometimes you really gotta take a swing, you know, and especially if you know that you have a good case, you have a good client, you're a good attorney. Is it always gonna go your way? No, it's not, because that's the system that we have. And sometimes those people in the jury box are not going to see it your way for whatever reason, right? You're not going to win every case you try. But I do feel like as I'm getting older, and 2002 graduate, so 21 years now, and maybe that's the right time in your career when you start to feel that way a little bit more. I don't know. I'm sure it's different for everyone, but just feeling, you know, just kind of believing in yourself and believing in the case, and believing that the jury will more often than not come see it. They will see it that way because we're on the right side. We're on the right side of the V. We're on the right side of the case. And most people want to do the right thing. I do believe that, you know. Are there people out there that want to kill your case? Oh, of course.
Yes.
But of course there are. Of course there are. But I believe that most people want to do the right thing. They want to reach the right result. And I think that we should embrace that and not be afraid of that.
Yeah. In your practice in general, Matt, do you, how do you structure the cases that you take to make sure you're having your best chance of having a great relationship with the client, having the time to dedicate to these types of cases because you're maybe taking them to trial? I mean, and more pointedly, how do you vet your clients to make sure they're going to be a good fit? Do you reduce your caseload so you have more time to keep with everybody? Tell us a little bit about that in the last few minutes here. I know you have to get to court, folks. I'm not trying to usher Matt off stage with the crook.
I'm happy to stay for another few minutes.
Okay.
Or whatever you want. That's such an important question. And especially with a small firm, a lot of contingency cases, not all, some employment cases, you know, we'll do some hybrids, but it's a lot of contingency work in general. Yeah. I mean, of course, case selection is so important. The vetting is so important. And I'm sure we've all learned the hard way over the years. It's never going to be perfect, right? Because we're dealing with humans and the idiosyncrasies of humans. But to answer your question, we have been spending an increasing amount of time up front trying to vet and trying to make sure that the cases that we're taking are of a high caliber and fit into what we're trying to do. And that definitely has resulted in rejecting a lot more cases than we used to. And I'm sure I've heard other members on podcasts talking about that. So this is not revolutionary, but I agree with it though. To me, it's not about necessarily taking fewer cases, but it's about taking really good cases that fit into our framework and our mission. And if that's fewer cases, that's fine. But if it's not fewer cases, that's also fine, as long as they're of that ilk, you know? So I do think spending extra time, even though you might feel like, oh, this is an hour wasted, this is 2 hours wasted up front, and if I don't take the case, I've just wasted that time. Well, I mean, that may be true, but boy, it's better than to get involved in something that you're deep into and you realize this is not what I thought it was. And now you're trying to get out of it, or, you know, whatever. We joke, but I want to be at the point, I think we're getting pretty close, where the phrase, why did we take this case, is not uttered.
Yeah.
You know? It would be great to be in a place where you just don't say that. Those words just do not come out of anyone's mouth. And I think we're pretty close to being there. So I'll let you know.
Yeah, that's that's fantastic. And everybody to take that, you know, to heart, because I mean, I like how you express that it's not necessarily a numbers game. It's quality and making sure that you have the resources and you can give the client. I mean, I find myself spending, just for example, yesterday I spent 30 minutes on the phone, and I had spent several, probably a couple of hours reading through documents for a potential client. And I just ended up spending time with her and even offering to, give her a couple more hours of time to help her with her situation, because it didn't make financial sense for her to hire me. It was going to be an hourly for what she was hoping to get out of the case. So, spending that time, I mean, it's great karma points at the end of the day. If nothing else, that person has a good thought about you in their mind, a good thought about your firm. And if you want to think about it financially, maybe they send you somebody, but that's
the thing though, they might send you your next great case.
Yeah. You just, and spending the time to really grab those quality cases and ensure their quality before, I mean, I believed in this person's case. It just wasn't, I was going to take more from her than she was ever, so. Right.
Yeah. Well, that was good, but that was good of you to explain that to her.
Right. Yeah. And I think a lot of clients don't think about that. They have the just, fight in their mind. I'm like, Will, let's talk about what this looks like for you and what you're hoping to get out of it. And are we on the same page? And can I achieve what you want? And so, yeah, spend the time, everyone. Spend the time, just making sure you're advancing the most just causes and with the most wonderful folks that you can.
Yeah, definitely. And, you do it's almost like some cross-exam almost in the beginning, not exactly deposition style, but really like pushing people, well, what about this? And what about that? And wait, this doesn't really add up to me. I don't understand what you're saying. You do it politely and professionally, of course, but like asking hard questions, in an employment case, get the personnel file. See what's in there.
Have you been written up before? I mean, do you have this long track record of sorted challenges in your firm? You don't want to wait until you
has anything happened? How was your previous job? Maybe even if you have the time, maybe talk to a witness.
Yeah.
Check, just try to vet, try to verify. And yeah, because again, as we've all known, sometimes you get into something and you regret it. And that's not a great place. That's not a great place to be.
Yeah. And give yourself, I mean, we have a cutoff. I don't know if you do, Matt, a cutoff for when the statute is and when we take a client. And I would say it's not a hard and fast line, but you want to give yourself the time to take a breath, as you say, talk to witnesses, really kind of get into then, because it's way easier to say to the client, hey, you know what, it's not going to work out after I've done some legwork, send you on your way, maybe go with somebody else. When they've got another year on the statute or, at least 6 months or something, than it is when you've taken someone close to it, you've filed because you had to, and then you get into it and you're like, ugh.
Right. Again, I'll keep agreeing with you. I do not like taking cases right before a deadline. And we almost never do that.
Yeah.
As
much as your heart might want to help them. Oh man. Can't.
Well, and we want to help people. That's
Yeah.
why we do what we do, is we want to help people, and we do help people, but you can't help everyone. And, I'm sure we've all been in those situations where sometimes what you say no to is more important or just as important as what you say yes to.
Absolutely. Absolutely. Yes. Yeah. I used to, when I was a younger lawyer, I thought if I have the facts and I have the law, I'm good. I take the case because obviously, and I learned over the years, there are so many more things that go into it, so many other factors, because I would have cases where I had great facts, great law, and a miserable client. And you wake up in the morning with anxiety about having to talk to them or having to, yeah.
Yeah. Right. 90% of your stress comes from 5% of the people in your life.
Mm-hmm.
And that's true for clients. But yeah, you're right. It's more than just the facts and the law. You have to click with the client. It has to be the right client. And also, I think you want to have a compelling story to tell. And that often involves some sort of, I'll use the phrase bad guy. I do think, and I'm sure I know Don talks about this, right? But having the jury has to get mad at somebody, right? I mean, there's got to be some point where the jury's pissed off. And I try to look at that as well, right? You might have a good tort case, but if it's an individual against an individual, let's say, the jury might get mad at that individual. I mean, obviously it depends on the facts and circumstances, but they might feel bad, like, oh, this person got sued, right? I mean, this is a whole other podcast here, but identifying, and oftentimes that is a company, right? That is a corporation that's more faceless than an individual. But yeah, I mean, think about that story and who's the good guy and who's the bad guy, and how could this have been prevented, right? And then all the stuff that we talk about. But you need a good bad guy.
No, that's very true. Because remember what Papa John always says, Bubba, don't give a shit about your client. So you might have the most wonderful client in the world. Having a bad client probably might harm you. Having a good client puts you kind of on the neutral, maybe a little bit up, but you have a good bad guy, and that's just going to take you to the next level. What do we always talk about? System failure, right? What went wrong? What broke down? Just as you said, Matt, was it?
How did we get here? Right? Yeah. Okay. How did we get here? And my case had that because of the sort of back history with the coach.
Yeah, you almost can hear, we talk about Jaws music, right? When you're telling me those facts, then you're like, well, the coach was allowed to stay on, and then another student, and then the coach is allowed to stay on. And I'm like, are you kidding me right now? We're heading for, snacks here, people becoming snacks of the giant system. So, all right.
Yeah. Well, Thank you so much. This was really great. Thank you.
You are welcome. Thank you very much for joining me, Matt. I appreciate it. I appreciate your insight and sharing about your trial. And thank you for all of you who watched today. We could not do it without you. I mean, what is the point of having a podcast if we don't have people watching? So thank you for watching. Click the thumbs up if you liked the episode. Don't forget to subscribe, hit the alerts icon. Next week, I believe we have a replay, although we have some speakers kind of in the wings, so we'll see how scheduling works out. Otherwise, tune in anyways, just to check out what replay we have. If you maybe haven't had a chance to watch it, might be a good time to check it out. So thank you all, and I have a great weekend, and I will see you next time.